Ready. And so I think the attendees are coming in.
All right.
I'll probably give just another maybe 3 minutes. We'll start at 1:03 to let everyone come in.
Sure. Yeah. No worries. Just let me know.
Welcome, everyone. I'm just going to give 1 more minute for everyone to come into the webinar. And we'll get started at 1:03. Okay, good afternoon, everyone. My name is Asia Mallory. I'm the consumer staff attorney at the Maryland Volunteer Lawyer Service. Thank you for joining us for our family law and foreclosure webinar. I would like to introduce you to our speaker, Walter Ty, from the law offices of Walter Ty. He will be our speaker this afternoon. If you have any questions, if you could put them in the question and answers box, and he will be able to answer your questions at the end of our webinar. So without further ado, Walter, you can get started with your training session.
Hi. Good afternoon, everybody. Walter Ty. I one of the volunteer lawyers, and I was fielding calls for the foreclosure assistance program, I guess, and how they related to family law issues. So, that there were a lot of interesting and kind of problematic cases, and I guess MVLS thought it would be helpful to see if I could kind of talk to everybody and give everybody kind of an overview on the things that I was seeing and any possible solutions. So, so foreclosure and family law, kind of how they intertwine, and the, kind of, I'm going to try to stick to the calls that I was kind of seeing, and really, the bulk of the calls kind of dealt with situations where there was either a divorce, separation of some sort, and there was jointly owned property, real property, and the divorce happened, and then years down the line, for the most part, foreclosure happened because the mortgage wasn't being paid. And so a lot of the calls were stemming from the fact that although there were programs to help with mortgage or foreclosure assistance, the applicant or the homeowner was having a problem qualifying for the assistance because, come to find out, the property was still jointly titled. and either the former spouse is, not willing to help, or can't be found, or for whatever the case may be, couldn't be located, or couldn't be removed from the title because they weren't participating. So kind of that's how what I found kind of the intersect was. But unfortunately, most of the calls, if not all of them, there was little I could do to help. And I hate to say that, but the reality is, once it gets to the foreclosure stage, there are things you can do, and that's why I'm kind of trying to get that information out there. But for the most part, most of the things you could do to avoid it would be to deal with it during the divorce and do it cleanly and properly. So I'll kind of talk about that in the end. But I guess for this, the initial portion of the seminar, the foreclosure part has already occurred or is looming. And how can you help? How can we help? What information can you give? So again, a lot of the calls were, situations where the ex-spouse was still on the property. And some examples were, I've been divorced for, I think, over 12, 15 years now. And he was supposed to sign the property over to me, never did. I lost my job. So now there's foreclosure, and I'm waiting on, I'm applying for help, but they can't they can't help me because my husband, my ex, is still on the deed. And that's unfortunate, but that's the reality, is that the programs for foreclosure assistance, I think, have to have both parties apply, or if whoever is on the title, because they can't really help if there's somebody on the title that's not applying or not participating. So so typically when there's real property in divorce, there's in best of all worlds, it's taken care of and cleanly, if you will. There's a house, the husband and wife lived in it, they got divorced, there's some agreement, the agreement gets put to a judgment of divorce. If there's no agreement, the court, if the court is asked to, has to make a disposition on the house. So either the court has ordered something, and typically that's dealt with under family law, Title VIII. And that deals with what the courts can do with real property in a divorce situation. So the court either orders the sale of the property or allows one party to buy the other party out, if they can prove that they can qualify for the refi, or if the one party who wants to keep the house was able to obtain a release from the mortgage company. So for the most part, 99% of us who have real property have mortgages. So basically, either the parties agreed to do something about the property in a divorce, or the court ordered something. So the first step that I take when I talk to the person on the line is, okay, so what's the problem? And if it is that the ex-spouse or ex-partner is still on the title, then I figure out what was supposed to be done with the property. Kind of dig into that and say, okay, well, what happened with the property? What happened in the divorce? What does the judgment of divorce say? What does your agreement say? So kind of I dig into that and find out what the disposition of the property was supposed to be. Now, again, typically hopefully there's some disposition, and you can kind of start there and see, okay. And typically it's, we agreed that I'm going to keep the property and I'm going to refi and remove the other party. Now, a lot of times that's just never done. And so if the foreclosure is already happening, I doubt that the refi was possible, obviously, because, the finances are not there. So that's a problem, because now, if you're going to if the agreement says that you're going to refi and you weren't able to do it, then typically the judgment of divorce says, if you can't refi, the property will then be sold. So in that situation, there's not really a lot you can do, because, if you weren't able to refi as a homeowner and remove the other party, or you can't, then the only other option is to sell the property. Now, but the really, so again, you kind of dig into what was supposed to be done with the property at the divorce. So either by agreement or by court order. Figure out what the disposition was. And if you can figure that out, if you're lucky, the disposition would be something where the caller has the ability to enforce. So for example, oh, well, the divorce judgment said that my ex-husband was supposed to sign the property over to me. And I guess a lot of people just, especially, different, the more wealthier, families, if you will, obviously they deal with it. They have lawyers to deal with it. Most of us have, problems and can't afford. So we just, a lot of the parties that call say, look, yeah, there was something supposed to be done, but I just never did it. I just kept living in the house and I thought everything was taken care of until now the property's being foreclosed on, and I don't know what to do. But so that being said, a lot of times, a couple of the callers, I found that, hey, the deed was supposed, the agreement was my husband was supposed to sign the house over to me, and so he never did. Now, in that case, if there is relief in the disposition of the home, so that's why it's important to kind of figure out what the first step is. What the first step is that figure out what the disposition of the home was. And so once you figure out if the disposition is something that you can still pursue present day. So again, in that example, the caller said, hey, look, I need to, my ex-husband was supposed to sign the property over to me. He never did. Now, that has some kind of caveats to it, because if there's a mortgage, you got to deal with the bank. But if for some reason it just says the property was to be transferred to me, husband was supposed to sign a quitclaim deed, I just never did it, there would be a kind of an easy-ish fix to that, at least in the sense of trying to get the property transferred to the caller so that they can now remove that party from the title. And that is to pursue the deed. So, in a lot of these cases, the pursuit, if you will, is either a contempt petition for contempt in the family law case, the divorce case, if that's what the disposition was in the divorce case. If you can file a petition for contempt, if there was an agreement, you could file a motion to enforce the agreement and kind of force the husband or the wife or the ex-spouse to go ahead and sign the deed. Now, if you're lucky, they know where the ex-spouse is. It's only been a year, or you can get the contempt or the motion to enforce through easily, because you can find the other party. Unfortunately, most of the calls, it's been years, or they don't know where the other party is. So even in a case where there's disposition in the divorce case, if they don't know where the other party is, then you got to either try to find them, and if it's impossible, it is also possible to ask the court to transfer the property by a trustee. Now, unfortunately, these steps that I'm kind of conveying are really the only things that I know of in the area of foreclosure and family law on how to deal with the issue, right? Property being foreclosed on, ex-partner, ex-spouse is still on the title, there's some disposition or no disposition. The only way to do it really is to go to the divorce court and say, hey, look, either here's what was supposed to happen to the property, it never happened, I need this to happen. Now, again, if you can't find the ex-spouse, you can still go to the circuit court, to the divorce court, and say, I tried to find the ex-spouse, there was some disposition that was to be done on the property, and I need the court to appoint a trustee to go ahead and transfer the property. So it's possible that even if the ex is not to be located or can't be located or won't participate, you can then ask the court to say, hey, look, I tried to get the disposition taken care of, but the ex won't comply or won't participate, or I don't know where they are. I tried to find them. I need the court to appoint a trustee. Now, mind you, this whole time, if the foreclosure is already looming, then, that hopefully the bank, most banks, most mortgage holders, they don't want to foreclose. So if you can kind of talk to them and say, at least I'm taking the steps, so that's what I would recommend to the caller. And that's what I did recommend to most of them, is to say, hey, look, you can tell them that you're doing everything you can to try and get the deed cleaned up so that the other person is removed from the deed. Provide them with all the documents, provide them with the, with the divorce papers. If there's an agreement, provide that to the bank and say, and now I'm filing a lawsuit, to enforce the agreement or to appoint a trustee. A lot of them will give you some time. So really the only thing you can do is ask them and let them know you're doing everything you can. Tell the party that they're doing everything they can and show proof that they are. Here's what I'm going to file. Here's what I have filed. So hopefully you can get the mortgage holders cooperation and giving you some time, or the party some time to try and fix it. So again, so you figured out what the disposition was or supposed to have been. If there was a disposition that can still be pursued, you can then recommend pursuit of that either by enforcing by contempt, or if that can't be done, then asking to appoint a trustee to go ahead and transfer the property, because the court can order that a trustee be appointed, make sure that everything is, being done, and then that trustee can actually sign the quitclaim deed to transfer the property. So it is possible to get the other party off the deed. But again, it takes the cooperation of the mortgage holder, the bank, to say, okay, we'll give you some time. And also, kind of the effort and the time and the money if the party wants to hire a lawyer to do that. It's very difficult, unfortunately. But really, those are the only things that can be done now. And that's, so that's even in the clean, so the cleanest case would be there was a disposition and was just never followed, and the property was to be transferred over to me. That's what the divorce says. You can get that done. Now, unfortunately, there are times when it says the divorce judgment or the agreement will say, okay, I'll transfer the property over to you, but you got to refinance me off of the mortgage. Now, if that's the case and the caller, right, the party asking for assistance can't qualify for a refi, which is a lot of times the case because obviously they're in foreclosure, they don't have the finances, there's financial trouble, doubtful that they can refi. So, the only hope in that scenario is for them to tell the bank, hey, look, either the property is going to be foreclosed on or you allow me to refi. That way I can remove the, ex-spouse off of the mortgage, and I can then now go to court and ask the court to transfer the property to me. And I could show the court that I have in fact refied or I'm qualified. So even though, it's late or whatever the case may be, I'm still doing what I was supposed to do. And now I can't find the other party. So there's kind of an extra step if there's a refi. If you can get the mortgage holder to agree to allow you to refi. Now, some of them will, all you can do is ask, really. So in these situations, I tell, all I can really do in this situation is to tell the caller, here are the things you can do. There are no guarantees that it'll work. But if you're trying to stave off the foreclosure and, you know the situation, here are the steps you can take. And really, that's all you can do. So, let them know the steps, let them know the things they can do. And if it works, it works. If it doesn't, then unfortunately, there's not much more as an attorney you could do. But so again, if there was supposed to be a disposition that included a refi, even if they can't refi, they can hopefully ask the bank to say, hey, look, the property is going to be foreclosed on. Can you just remove my ex off of the note? He was supposed to give me the property anyway, or she was. Now, sometimes if you're lucky, the bank will allow that. But as we all know, banks want to hold as many people accountable as possible. So I find, unfortunately, most banks will say no. I mean, why are we going to let go of, two debtors in the event of a foreclosure, which is already happening because we can sue the both of you? Why would we let the other party go? But again, all you can do is recommend that the caller try and let the bank know, here's what was supposed to happen. I need them off the loan. And even if the bank says no, there's no harm in telling the party to go ahead and file a request to appoint a trustee to go ahead and transfer the property. Because at that stage, I mean, if the trustee transfers the property, the court approves it, the trustee transfers the property over to the one party and says, okay, there's a quitclaim deed, go ahead and record it. The bank still holds the note, but that may at least allow the party to go ahead and apply and possibly qualify for the foreclosure help, which is in the end what you're trying to do. So again, either file a petition for contempt to enforce, file a motion to enforce an agreement if there was an agreement. There wasn't an agreement, then really the contempt is all you could do. If there was some type of refi that was required in the disposition of the property, try to get that done. If it can't be done, then go ahead and still try to get the court to appoint a trustee, transfer the property if the other side is not cooperating. So, I mean, really, that's the advice that I was that you're able to really give the callers. Now, there are situations where there was no disposition. Now, I had maybe, in my career, a few calls where people call and say, we got divorced, and we just agreed that I was just going to continue to live in the property, and we didn't even tell the court. And the court, in a divorce case, the court will ask, you have to ask for the relief. And if you want a disposition on the home, you have to tell the court in the divorce, hey, look, we have real property, we want it dealt with in the divorce and so forth. Now, regularly enough, unfortunately, you come across cases where there was no agreement or no disposition on the property. And the parties just got divorced and told the court, judge, we just want a divorce. Our kids are grown. We don't need child support. We don't really have any property issues. And the court will give you a divorce. And they will ask you at the divorce hearing, there's no disposition on property. You understand you can't come back and ask the divorce court to take care of the property and so forth. So there have been a few times where that's happened. So now the person calls and says, hey, we never really did anything about the house. We just agreed I would live in it. I've been paying the mortgage. So, everything's fine, but I lost my job or whatever the case may be. And now there's a foreclosure. And so in that situation, there's no disposition. So kind of going back to step one, what was supposed to happen to the house? And you look back and they tell you there's no disposition. We never told the court, we just kind of agreed for me to live here or whatever the case may be. Or there was just no disposition on the property in the divorce. So in that case, now there's a foreclosure. What can that party do? Kind of the same steps though, right? It's just now you don't know, the presumption now is though that the house is now, once the marriage ended, it's now, so kind of stepping back, when you're married, property is T by E. If you own real property together while you're married, it is titled tenants by the entireties. And that means that both parties, while they're married, own the entire property, not just a portion of it. So, wife owns 100% of the property, husband owns 100% of the property, but obviously subject to the mortgage. So they both kind of own 100% of the property. If they're divorced, and even though nothing is ever done to change the title, the presumption is that at the divorce, that property then converts to a joint tenancy, a joint ownership. So in that stage now, it's no longer T by E, it becomes subject to ownership interests and argument on who owns more and less, if the divorce court never dealt with the property in the divorce. So let's say in that scenario, nothing was ever done with the property in the divorce. They never told the divorce court. One spouse just lives in the house and it's been years, and all of a sudden there's foreclosure. Now, the remedies are still the same, but the problem is that now the husband, whatever the agreement may have been, unless it was in writing, still now, the ex-husband or wife or this ex-spouse who doesn't live in the house and just kind of said, you can have the house, you can live in it, but never transferred. And it's happened regularly in my career. Now, what do you do? Well, it's the same remedies. You have to either have the the spouse signed the property over by quitclaim deed, subject to all the issues with any mortgage existing and the bank allowing the mortgage to be transferred to one party and all that I just talked of. Or, or the other party then says, no, you got to buy me out and I have interest in the home. So that's a whole mess that kind of hopefully rarely happens in any situations you guys may come up with, but or encounter. But if it does happen, the remedies are the same. Either you have to pursue, the remedy is the same in the sense that you got to go to court. But at this stage, if there was no agreement, you got to either now find the ex-spouse and force a transfer of the property based on an agreement you allege existed, or whatever grounds. But if it's just the property remained jointly owned and it was never disposed of in the divorce, and now you're kind of just in a foreclosure situation and you don't know what to do, you can contact the ex-spouse and say, hey, we're being foreclosed on. Can you transfer the title over to me so that I can qualify for mortgage assistance or foreclosure assistance? Or the ex-spouse may want to participate. So the incentive would be to tell the ex-spouse, hey, look, we can deal with the ownership interest later. I know we never transferred property. I know we never agreed on it, but now it's being foreclosed on and we're both going to be losers. So why don't you go ahead and participate and go ahead and apply to the program with me? So that's another bit of advice you could give parties in that situation, is to say, hey, it's probably good for the both of us to go ahead and participate and apply for this program, because if not, then we both lose, the property gets foreclosed. So kind of in that situation, kind of a silver lining is, the other party may want to participate because now they can save some property interest and figure, dollar signs in their mind. Okay, well, I own interest in this property, I better try and save it. And then side note to that is, if they don't try to participate, then the foreclosure is going to affect them as well anyway. So that's kind of, on the side, is that all the negative effects of the foreclosure are going to happen to that other ex-spouse, whether they want to participate or not. So incentive for them to participate is, hey, if we participate, you sign the papers, we can deal with our ownership interest later, but let's try to save the property. So that's kind of, you can tell the caller or the party to try and convince the other side of that. Let's see. So typically, the transfers are done. If a transfer is being pursued, right, by the caller, and they're able to locate the ex-spouse, or they're willing to participate, then the quitclaim deed, kind of good thing is it's easy to get done, because the quitclaim deed is pretty quick to get prepared and easy to file. But again, you have to kind of make sure that the bank is aware of all the things you're doing and they're approving all of these steps as you're going. So again, unfortunately, there's a lot to it, but these are the only things you can really do if you're the party that is being foreclosed on in these situations. So, so kind of that's the bad thing about it is the avenues of relief that you can pursue are kind of daunting. And I, realized when I was talking to the people calling in, when I'm explaining, okay, here's kind of options you can pursue, they're immediately kind of daunted by the gravity of the task. And it's like, I can't do all that. I don't have time to do that. But the reality is, if you don't, those are the only things you can do. And if you don't want to do it or don't have time, and I let them know, look, it is what it is. These are the things you can do. And it's really the only thing you can do. Either pursue, the enforcement of the agreement you had that will allow the transfer to you because it was dealt with in the divorce or an agreement. If not, then you still have to pursue it via court to go ahead and force the transfer. Or ultimately, also, I guess another remedy that can be pursued is that you can just go ahead and ask, I tell the callers, look, if this is too much, or you can't do it, or you don't want to deal with it, you can ask the bank if they're going to allow you to sell the property or explore a short sale. You know, if there's enough equity in the house, and the court kind of, I mean, the bank, you know, who wants to avoid foreclosure in the first place, they may say, okay, you know what, we'll give you some time to try and sell the property. And you can do that, and at least you can salvage the homeowner's interest in the property and stave off the foreclosure. So that's an option you can explore and try to explore, or a short sale. You know, if there's not a lot of equity in the house, do a short sale, anything really to try and keep the foreclosure from happening. So let's see. So in the case where the property was not dealt with in the divorce. So again, kind of going back, if there's foreclosure and you find out that the party says, we never dealt with the house, I just continued to live in it. My husband says it was okay, and it's just been 10 years and I've just been living and paying the mortgage, and now I can't, there's a foreclosure. And we didn't really agree on what to do with the house. Now, if that's the case, you could tell, and the property is not being foreclosed, and you can buy some time from the mortgage company in a sale, then you know you could pursue the sale of the property through the court, and you would have to file a sale in lieu of partition of the property, ask the court to sell the property. So kind of that's hand in hand with that scenario where there's no disposition in the original divorce or by agreement. And also, you know, if in any of these cases, honestly, the easiest way to deal with it is to hopefully find the spouse, because first of all, the ex-spouse. If you cannot find the other party, it then adds a whole layer of things that you need to do to try and prove to the court that you have tried to find the other party. Because just like any lawsuit, you know, service is an issue. Plus, in this situation, it's there's title, there's property, so they have rights as a property owner. So now you got to try and tell the court, well, I tried to find so and so. So again, there, you know, hopefully, that's not the case in the fact that they know where the other spouse is. But if they don't know, you know, you got to take some steps to try and find them. And then if you can't, then you can try to tell the court, okay, I need a trustee appointed to sell the property or transfer title because I can't find the other property, the other party, and here are the efforts that I've tried. So there's just honestly a lot to consider, you know, and the fact pattern of the situation kind of dictates where you go. So that's why I'm kind of like trying to, you know, when I talk to these people, that are calling in, I kind of try to do it in stages. Okay, you know, again, what's happening? Foreclosure. Okay, how's the property titled? And if they don't know, a lot of times they don't know. Unfortunately, you know, they just don't know. You could look up on SDAT. You could, you know, look at the title on property. If you're an attorney, you can sign up for a land records account and you can actually pull up the deed for free. But if not, you can just look at the SDAT and it'll tell you how the property is titled. So you can look that up. And sometimes, rarely, you know, they don't even know. But I've had a couple of cases where, you know, client says, I have no clue. We used to both own it, and I don't know what happened. And I look up the property, and the ex got it all done without, you know, the party knowing. They might have signed something that they didn't know or didn't remember. But if you're lucky, that has happened and the property's already been transferred. But again, in these cases where the people have called in, most of the cases, if not all of them, were situations where, hey, I'm being foreclosed on and I can't get the assistance because the ex is still on the deed. So, you know, in the cases that will run into through MVLS and housing assistance will probably be those cases where, you know, that luck doesn't apply and it's just property was just never dealt with. So now there's the other side to that coin where all of a sudden, you know, you're, you know, the caller says, hey, look, I've been divorced for years and now I'm getting foreclosure notices on this house that I thought I transferred over to the ex, and now it's being foreclosed on. I don't know what's happening. So sometimes that happens where, you know, a deed, let's say in that case that, you know, let's say the husband, oh, I signed the quitclaim deed and I just kind of, you know, gave it to the ex-wife and she was supposed to record it and it never was. So unfortunately, in that case, you know, again, you have to look at what the remedy was in the family law case or the divorce case or the agreement that they had. But if it was some kind of transfer, you can, you know, in that scenario where you're the other party, you're the party that had given the property over to the ex and they just didn't do anything about it. The relief is the same, where you'd have to pursue it in court by contempt for by enforcement of the agreement. Or to go ahead and, you know, if you can't find the ex in that scenario, same thing, the trustee, appoint the trustee to transfer the property. But in that case, in all likelihood, if there was an agreement that the property was going to be transferred, or, you know, the caller says, hey, look, I signed the deed, or the property was supposed to be transferred, in that case, you know, there was some disposition, and you could probably get that party to get the breach, if you will, of not having the deed or the instrument ever recorded or finalized, is to just file for contempt or breach of the agreement. And that way it's a little bit easier from that angle, because you're just trying to say, I just want off the property. You know, I don't want to be involved in this. My credit's being affected and so forth. So in that situation, that party clearly doesn't care whatever happens to the house. They just want off. So the remedy would be the same in terms of what you would file: contempt or breach of contract or breach of agreement. But in that case, that would probably take care of it and just say, you know, the ex is in contempt because they were supposed to remove me from the deed. I gave them the deed. They never filed, they never recorded it. You can order the court, you can ask the court to order that party to go ahead and record that deed and remove you from the from the title. So sometimes that happens when it's the reverse. Let's see. Some other scenarios I came across. Let's see. Oh yeah, there was a call or two of yeah, we so we got divorced. Yeah, this lady called and I called her and she said, you know, well, we did get divorced and this was years ago, and we agreed that I would just continue to live in the house and that I would pay the mortgage, and you know, and that was the agreement. And they just never really agreed on what would happen to the house ultimately. So in the case of a foreclosure, in that scenario, you know, the same relief, but it was a little bit unusual in the sense that, you know, well, what did you tell the divorce court? I'm trying to remember that. They just never told the divorce court anything about the property. So I guess it's similar in the sense of the scenario where there was no disposition in the divorce case, where it's just, we just got divorced. We kind of formally agreed I just live in the house, and now it's being foreclosed on. Kind of same scenario of the ex-spouse, even though the ex-spouse says, yeah, it's the wife's property, I don't want any part of it. Unfortunately, under the law in the foreclosure, the ex-husband in this scenario was still liable on the note because he was never removed. You know, because the promise was, I'll pay the mortgage, so it won't affect your, you know, in fact, it'll help your credit, ex-husband, because I'll pay it timely and so forth. And so, but unfortunately, obviously that didn't happen for some reason. And, you know, and so now the ex-spouse is probably going to say, hey, you know, if you're trying to save the property, I've got an interest in it. So that's kind of an aside. But in that scenario, if the person calling says, hey, this is what we did, we didn't really have an agreement, I just continued to live in the house and paid the mortgage, and now I'm being foreclosed on, I would still tell that person to say, to try to find the ex and get them to cooperate and say, hey, look, either you cooperate in applying for the foreclosure assistance, and you know, I'll agree that you'll get some percentage of the house ultimately when I sell it, or whatever it may be. That's one way to salvage it, because again, you're giving an incentive to the ex, who may not at that point, who may have thought they didn't have any interest in the house anymore or didn't care, and all of a sudden, you know, they can get some kind of monetary or financial gain from it, that will be incentive for them to go ahead and apply for the foreclosure assistance or help in any way to stop the foreclosure. So that's kind of one bit of advice is, it's kind of the same for most. If you can get the ex to participate, that is the best remedy, whatever the disposition or non-disposition was. Because in the end, if they agree to participate by either following through with what the agreement was, or signing over the property by quitclaim deed, or applying for the mortgage or foreclosure assistance, in the end, you're helping the caller, right? They're stopping the foreclosure or and at least qualifying for the assistance. So there may be a price for them to pay, but if that's their goal, the easiest thing to do is find the ex, get them to participate, either by signing the deed again or just participating in the program, and then deal with the implications later. Because the bank, the foreclosing bank will be happy to stop it if the foreclosure assistance comes through, then the bank's going to be happy. Now you've bought time, at least as the homeowner, to say, hey, now I can deal with the ex-spouse. Maybe I may have to pay them off or whatever it may be. Find more time. Or in the end, if they have to, continue to do what they're doing, as long as the foreclosure is staved off, point being is that you've given them time to stop the foreclosure. So that's one of the scenarios that kind of came up. Let's see. Now, and it was unfortunate, but kind of lesson learned for the callers, right, and their lives moving forward. Unfortunately, a lot of them, were older, but point being is, if there's a divorce, the easiest way to avoid the foreclosure is to have dealt with the property cleanly and properly in the divorce, whether by agreement or asking the court to make a disposition during the divorce. So if for some reason, kind of on a related note, if you run across, somebody in your professional lives saying, hey, I'm about to get divorced, or there's property at issue in the situation, you want to make sure that you give them the advice or tell them to get the advice from a knowledgeable attorney as to dealing with the property now, as opposed to waiting for it. And I never recommend, as a family lawyer, at kind of, more of the avoidance kind of scenario of these situations. I never recommend kind of, loosey-goosey dispositions on property. I'll continue to live in the home and pay the mortgage and we'll deal with it later. I always tell the parties, look, you want it clean, you either refi or buy them out now, or, and if they can't, the property has to be sold. That way you don't have to worry about it in the future. So kind of side note is, more preventative wise, you want to make sure that, in your professional lives, or, even, family members or friends ask you, hey, I'm getting divorced, what, make sure that real property is dealt with cleanly and specifically, so that these issues don't arise in the future. But, again, I know we're more on the foreclosure end, but I just kind of wanted to touch on that. And so, on the foreclosure end, let's see. So, really, I mean, I was trying to take notes on the big points and what I was getting when I was talking to the people calling in, and that was that was really, it's really difficult to untangle these once the foreclosure has started. And so I know that's kind of like, well, gee, thanks a lot for for nothing, really. I mean, but the reality is, once the foreclosure starts or is looming, it's really hard to stop unless you're lucky. And again, there was a disposition in the divorce that is easily achievable. So it's kind of key to figure out in the beginning, hey, let's see what they were supposed to do with this property in the divorce. And if there was a disposition, kind of, okay, I can still probably chase this fairly easily, but it still takes time, because again, you got to find the ex, you got to get their cooperation. If they're not cooperating, you got to go to court. So all the while you're trying to stave off the mortgage holder that's foreclosing. But at least if you tell them, you know, if you're able to tell the foreclosing bank, look, here's what was supposed to happen to the property. There was supposed to be a transfer and it just never happened, but I'm pursuing it now and I've filed a contempt or the breach or the petition to enforce, and I filed it and we found them. If you tell them that, then there's a good chance that they'll give you some time to say, okay, you know what, because they don't want to foreclose. So if they can avoid it. So there's a little bit of a silver lining in that. But, you know, more than half of the callers were, hey, look, you know, I was supposed to, you know, I don't know where the X is. And really, we didn't really specify what was going to happen to the property. That was regular enough in the calls that I was getting. So that was unfortunate. And that's why I kind of put that reminder in the end to say, you know, if you ever get the chance to advise someone in a divorce or that type of situation, or even just a jointly owned property, it doesn't have to be a divorce. You got to make a clean break and make sure that the steps are there, that if things go south, you know what happens to the property and there's a way to get it enforced. That way it's, you know, if things go south in the future, you know, in this disposition you've made, you know that you have a way out if you somehow can't pay the mortgage. So, but again, you know, once it starts, it's really hard to stop the foreclosure. And you really just have to be kind of lucky in the sense of if there was a disposition, you can pursue it. And point blank, kind of unfortunately, if there was no disposition agreed upon in the divorce or nothing ordered because they just ignored it and the foreclosure's already happened, it's, you know, there's little you can do to stop it because at that stage, you know, it's just too late. But, you know, not that there's nothing you can do. Again, you can try to talk to the ex, offer them some kind of monetary thing to participate. But if that happens and there was no disposition in the divorce or or the disposition of the property, if it was just a jointly owned property, it's kind of, you know, once the foreclosure starts, it's really unfortunate, but it's difficult to stop. So let's see. So yeah, so that's kind of you know, those are the things I kind of learned, and as I was fielding calls and trying to give advice. So kind of if anybody had any questions, leave the last bit of the seminar to answer your questions.
All right.
So there's a question. Did you mention at what point do you involve a bankruptcy lawyer? You know what? Good point. You can pursue a bankruptcy. Let's see. If you're being foreclosed on, you can pursue a bankruptcy, and at that stage, yes, you could. But that typically would not. Let's see. Let me think this through real quick. I didn't run across that scenario, right? So most of the people I was getting in touch with were already in foreclosure, and they were trying to kind of stave off the foreclosure by getting the property transferred or getting the other side to participate. So if you do file a bankruptcy now, I used to do bankruptcies, but not in a long time. So at that stage, I think there might be an issue in the sense of what happens with the property, because if it used to be a marital, you know, a jointly owned asset in a marriage, different rules apply to in bankruptcy to that, as opposed to when it got converted over into just a jointly owned property once the divorce happened. So, you know, a good point. You know, I guess a good practice would be to tell that party, hey, look, talk to a bankruptcy lawyer because there may be methods in bankruptcy that could stave off the foreclosure. Yeah, sure, definitely. I mean, thanks for pointing that out. Yeah. I don't see any other questions.
All right. I don't see any more questions. I mean, if you have questions, you can feel free to put them in the question and answer box.
And yeah, you can. And if you guys have any, you know, follow up, I'm sure Asia can give you my email, my contact info. feel free to, reach out to me. I'll try to help as much as I can. To me, it's, I also, although I've been doing this a long time, I also learned in this process. So, sometimes your questions like that question kind of led me down oh, okay, yeah, I gotta, kind of incorporate that into my own kind of thought process when I deal with these situations. So again, feel free to reach out and let me know if I can help in any way.
All right, seeing no more questions in the question and answers chat. Thank you, Walter, for this presentation. It's always good to learn about how to help clients who are facing foreclosure and having a family law issue.
Yeah.
For all of the participants and all the guests or attendees, remember to follow MVLS on our social media platforms. If you have any questions about family law and foreclosure, feel free to reach out to me and I can put you in contact with Walter to ask you about any clients that you have dealing with similar issues. This training has been recorded, so in the next few days, it will be available on our website and on our YouTube page. Thank you again
All right.
for
Thank you so much, guys.
attending, and thank you again.
Thank you so much. Appreciate it.
All right,
Thanks.
bye.
Bye.